Thank you, Mr. Chairman. Thank you for your willingness to jog with me. Madam Chair, you had a number of questions on the Section 5 authority, but let me just concentrate for a minute on that and then move on. First of all, I'd like to ask unanimous consent at this time that the Tiversa report be placed in the record. Unanimous consent.
Without objection.
Thank you. Section 5 authority, as you mentioned, one of your commissioners, Mr. Wright, clearly is proposing that there be a standard. Leaving that alone as to what the standard would be, isn't it reasonable for us to see from this side of the dais that if there is no standard and the staff is not bringing you votes on particular events, then by definition the staff is making decisions without specific guidance, and you're abrogating what should be your authority? And the reason, and I'll just put a question in this specifically, until you have specific standards on which to judge, shouldn't the Commission have to be informed and, as appropriate, vote before these actions go forward based on what is effectively less than sufficient guidance?
Let me address two issues here, and I want to be very clear. First of all, I don't think it is accurate to say that there is no standard. There absolutely is a standard, and the standard is whether conduct by companies have an adverse impact on either competition or on the competitive process. I think that's been very clearly established.
But you use Section 5 authority when somebody simply gets hacked and their data is out there based on, quote, they're not using a sufficient care, on which you have no standard.
So let me clarify. What you're talking about has to do with our Consumer Protection Authority, which relates to something separate from our Unfair Methods of Competition Authority. We do have, we are exercising our authority under Section 5, which bars deceptive or unfair practices.
Right, but I want to focus this. The Tiversa, the LabMD case, which was a data breach, which was, if you will, failure to maintain personal identifiable information, used your Section 5 authority. We followed that case. So you're clearly using an authority for data breaches. And
we are.
Okay, so now that we've established you're using, because I have very limited time.
Which is different from what Mr. Wright is.
Yeah, no, I understand, but I want to stay on Section 5 authority and the examples that I put in the record. Yes, all of this is within Section 5. Let me clarify. Now, back to Section 5. You also don't have a standard for, if you will, a safe haven for data protection. You have no outside group that sets standards. You have no specific standards. So your standard for going after a company that has a data breach is they have a data breach. Isn't that true?
No, that's absolutely not true.
Okay, if they don't have a data breach, have you done any Section 5 actions for data breaches?
I'm sorry?
You haven't. If there's no leaking of personally identifiable information, you don't go after them. When you find out they do, you go after them. And yet you have no standard where someone can say, if I do this, if I hire this company, if I am ISO 9002, if I'm whatever, it's a safe haven. So let me go through this process for a moment. In the case of many of your enforcements that we've been monitoring, what happens is the data breach itself becomes the evidence, and at the end of the day, they enter into consent decrees because they want you off their back, not because they know exactly what they should have done to have not had it. In the case of Tiversa, or in the case of a case that you passed on, and I appreciate that you passed on it, which was a free AIDS clinic in Chicago, who had a data breach that turned out to be based on a stolen laptop, the result of a breaking and entering, that then Tiversa informed you about, that then Tiversa informed their lawyer about, that then that lawyer sued by getting those victims, those AIDS patients, all riled up and suing the AIDS clinic. So as we go through this, the question I have for you is, until or unless you have a standard of care for a breach before it happens, so that people know that if they assert this, they have a safe haven, which we do in antitrust and most other areas, you can define it, shouldn't your focus switch to those who mine data, those who hack, those whose use of somebody else's data, in fact, is inappropriate, rather than those, for better or worse, who get hacked? And I'll close with this. You don't have the authority to go after the State Department, the Veterans Administration, Congress, or any of these other government agencies, all of who have had massive data breaches. Why is a data breach in your focus? Is it just because the breached company is easy and the hacker is hard? So whatever time the chairman will allow for you to answer.
If I may.
Yes, please.
So I want to clarify that we do have a standard when it comes to enforcement actions in the area of data security. Companies are required to, under Section 5, have reasonable security measures in place to protect consumer information. So that's
That standard has been, we've asked for it, and you haven't published anything other than those words.
We absolutely have a standard where we use both under deception as well as unfairness.
Well, we'll follow up with any additional information you can give us to show where a company can know a safe haven so it can be published and they can know what they need to do to be immune if there is a data breach and they've met that standard.
And I would be happy to supply both. We've got more than 50 cases in this area. We have guidance, and we're continuing to provide got more guidance to companies. Just one more very short point, and that is that I also want to make clear that no investigation at the FTC is commenced without senior management supervision, and there won't be any conduct that is any conduct remedy that is imposed, or any remedy of any kind that's imposed without a commission vote. So I want to clarify that point.
Good. Thank you. We will go into